Still morning here. And I'm all excited. I'm talking a little bit today about common law copyright. The title of this has gone through, I'd say a few changes, but a few reductions. This started as the scope of common law protections for pre-1972 sound recordings. And it's slowly been chipping away at that. And so this is what I'm working with now.
Get it started.
Oh. Okay.
There we go.
All right. Ready where you are. So yes, common law copyright. Exciting, timely, in some ways. So, federal protection for sound recordings. A lot of you are going to be familiar with this. Under federal law, you have this old decision in 08 that piano rolls couldn't be copyrighted. Following year, Congress does not include machine-readable sound recordings in its in the Illinois statute. And so, for about 60 years, the Copyright Office refuses to register sound recordings. You can register an underlying composition, but not the sound recording. So in '71, they passed an amendment that says that all sound recordings made going forward are entitled to federal protection, and that the date they set is February 15, 1972. Everything before that has no federal protection. Everything after that can. So that's that. Now, the current federal law at Section 301C makes it clear that any state protections for sound recordings made before 1972 are not preempted by the copyright law. It follows Goldstein as well. So, there is no general right of public performance for sound recordings. This is sort of a unique thing, or phonograms, if you will. Everything from playing music at a bar to music on a radio. There is a right of public performance for an underlying musical composition. That's why you pay royalties to ASCAP or BMI or CSAC. But there is no right of public performance generally for sound recordings. It's only for the underlying composition. There is a narrower right of public performance for digital audio transmission of sound recordings. This includes satellite radio and non-interactive internet radio stations. So this is satellite radio, Sirius XM. This is Pandora. It's not necessarily Spotify, but Spotify gives you a lot of leeway about what you're going to play, which is a little different. So those royalties for digital audio transmission are handled by Sound Exchange. And the royalties that are paid by Sound Exchange are generally much higher than those that are paid by ASCAP or BMI. This is a line from a New York Times article that was published a couple of days ago. But the Sound Exchange paid out $773 million last year. Now, that's the equivalent to about 16% of record industry's total income. It actually is a straight quote from the New York Times. So, Sound Exchange, which was a tiny player when it was first created in 2003, is now providing 15% of the income to record industry. And a lot of what you've heard lately about, there's been a lot of controversy about, for instance, Taylor Swift pulling her song from Spotify, etc. And this relates to the fact that the song, back in the day, the songwriter, the composer, the person who wrote the music, was the one who really cashed in. That was what was really worth some money. The actual sound recording copyright was not worth that much money because you couldn't get paid for it being played elsewhere. Obviously, as the scope of the landscape has changed, the sound recording copyright becomes dramatically more valuable. And you have a wrinkle because obviously it only includes sound recordings made in 1972 and after. So for before that, you have this really improvised legal regime which uses common law copyright. So common law copyright is a legal doctrine that an author has the right of control over their unpublished work. You have this decision 37 in Pennsylvania that has it for some controversy in New York State, but by the Knoxville decision in 2005, New York State has fully embraced the idea of common law copyright. The idea of a perpetual, that you effectively cannot publish a sound recording, you have perpetual protection in that sound recording. A number of other states have adopted this view, a number have rejected it or have removed common law copyright by statute. For the vast majority, we have nothing. One part of my paper I'm sort of excited about has actually had a 50-state survey of the common law protections by state in it. So that is sort of exciting. But the result is sort of most states haven't taken a position. You have about 15 to 20 that have. So 48 states have criminal statutes regarding commercial and for-profit piracy of sound recordings. We're going for 72. The exceptions are Vermont and Indiana. However, 48 states have this rule. It has to be commercial. It has to be commercial for-profit use of these sound recordings. California is the only state with its own civil statutory regime. Unfair competition, right publicity, conversion, and others have also been considered. So, there's been some really interesting work about, these proposals in the air and some really interesting hearings about federalizing these older sound recordings. And that is not really what this paper is about. It's sort of in the shadow of all that. What I'm trying to say is, okay, that's what we're thinking about doing. But what do we actually have now? And there's precious little scholarship or information about what common law copyright really is. There's sort of a certain received wisdom. Common law copyright is like statutory copyright. I don't think it is. So initially, statutory copyright is obviously a creature of statute. Common law copyright is viewed as property, whether it's personal property, real property, but there's different arguments on that. Perpetual term for common law copyright versus limited term for statutory copyright. Common law copyright must be unpublished, statutory copyright must be published. These are all things that most people who do some research into discover pretty quickly. Here are a few other things that the next line not everyone knows, but it kind of makes sense if you think about it. There is no statutory damages for common law copyright. You may have right to punitive damages, it's been applied in a few cases, but there's no statutory damages. The one thing that has been at issue in some litigation, I'll talk about this in a minute, is there a performance right in common law copyright? And in statutory, as I said, there is a performance right for some works. The other interesting thing, and this is there a reproduction right in common law copyright? And that may sound strange, but I'll explain what I mean about that in a minute. There is clearly one statutory copyright. That is the core of statutory copyright, the reproduction right. So a few lawsuits, Calp Record versus Pandora. Pandora has failed to obtain licenses or pay royalties for playing pre-1972 sound recordings. Pandora had indicated in SEC filing that individually negotiating these licenses would be crippling. Case is currently pending. Flo and Eddie Inc. versus Sirius XM Radio. When you say Flo and Eddie, not everyone knows what you mean, but when you show the record cover for Happy Forever, everyone says, oh, the Turtles, so Happy Forever, etc. So Flo and Eddie sued Sirius XM, asserting their own royalties. They sued them in the federal district courts in New York, California, and Florida. In California, the court held that there was a performance right in the California statute. In New York, the court held there was a public performance right under New York common law. In Florida, the court held Florida did not grant a performance right. And further, the court was silent as to whether Florida had common law copyright at all. So you have these three different holdings in three different states. The idea is Sirius XM had these operations in these states, and that's why they sued then. So this is one of the areas that's new in my paper. That even though you start thinking, okay, how can we have an analog? You don't have a performance right for sound recording under a lot of federal law now. However, could there still be a performance right for sound recordings that were made that could there still be one under common law? And see, so I started thinking, well, wait a minute here. You had a long period where there was no performance right for music, but courts did in fact recognize a common law performance right. And in fact, you have a number of cases where the common law copyright and statutory copyright differed, where you had a public performance right under common law, but not under statutory law. A few cases I'll run through quickly. I think this one's our cool talk about here. Goldmark v. Colmer. As far as I know, this is the only copyright case ever decided in the circuit court for Cook County. This is a case that if someone tried to pirate the Strauss operetta Der Lustige Krieg, or A Merry War, and the Chicago court held in ringing terms that Strauss had a right of public performance in his work. This, and mind you, in 1882, Strauss was a foreigner. He couldn't get copyright in America no matter what he did. Beyond that, there was no public performance right for music anyway in America until 1897. Didn't matter. The court held that Strauss had a common law performance right in his operetta. So, Thomas V. Lennon involved oratorio of redemption. The court held that public performance was prohibited, even though a piano reduction with libretto had already been published. And then you have two other cases. Let's go through them quickly. Carte v. Ford, this is about the operetta Iolanthi. The court held the public performance was lawful because what they did was the piano score and libretto had been published, and they made their own orchestration. They published their own orchestration. Court held that this performance was lawful only because they used their own orchestration. If they used a manuscript orchestration, it would have been a violation of common law copyright to do a public performance. Mikado case, essentially the same holding in 1885. In all of these cases, you had Gilbert and Sullivan actually went through some fairly lengthy legal machinations to make sure that they had protection, that they had some U.S. protection. But the court held that even though they had a valid U.S. copyright for the piano score, if it's published, there's no public performance right in the published piano score, but the unpublished manuscript orchestral score would have common law copyright protection against public performance. And then Goldmark v. Creeling, one more, pretty much the same thing. The takeaway in a nutshell. And if you look, this line goes straight through the cases. Public performance is at the core of common law copyright. That it's irrespective of what the statute does. There are, as far as I can find, no cases that go the other way and say no, there is no public performance right. And further, it does not correlate to the statute. Common law copyright does not necessarily correlate to what the statute grants you in terms of public performance. It has its own set of rights, and on public performance, that set of rights is broader than what the statute gives you. So this is, up to that point is what I talked about it with it. This part is new, and I think it's a little, I'm pretty confident with that part. This part is a little shakier, but I think it's actually interesting conceptually. So we talked about what area or common law copyright is much stronger than statutory copyright. What about an area where it's weaker? And this is an interesting thing. The core of statutory copyright is reproduction, whereas the core of common law copyright is distribution. This is sort of the basic fact about common law copyright. It's all that you have a right to keep your manuscript to yourself and to control distribution. However, the leading pre-Noxus New York case, which is cited literally hundreds of times for this proposition, said, well, not over 100 times this proposition, makes it clear there is actually not a reproduction right under common law copyright. And this, yeah. So, sorry, I think we have a little bit of order here. The author does not have a common, this is a line from Hammer. If you look, this is cited by every major New York common law copyright case, up to and including Noxos versus Capitol Records in 2005. And it's pretty unequivocal. The author does not have a common law, any exclusive right to multiply copies of their control to issues copied by others. The right of an author or writer to literally work is to multiply copies of it to the exclusion of others is a creature of statute. In other words, Noxos said, relies heavily, but says it only means that this line only means post-publication. And so there's two separate things going on here. One is saying that you can't control distribution after publication. But the other is that there is not a reproduction right at all in common law copyright. And I think this makes sense, if you think about it. The idea was, no one called it common law copyright, believe it or not, until the 1920s. I mean, it was called impression manuscripts, etc. It wasn't really called that. If you look in Westlaw, there are about 400-something uses of common law copyright. A lot of them are older cases, because the doctrine had its heyday before, in the older days of copyright. There are exactly 12 cases that use the term common law copyright prior to 1925, only 2 before 1896. Actually, well, one in 1896, one before. No one used the word common law copyright to mean the manuscript right up until the 20th century. When the doctrine was developing, the word copyright wasn't used because that implies a right to make copies, and that's not what the common law copyright is about. And so, wait a minute, does this make any sense? Oh, this is one more cool thing. This is uses of a phrase common law copyright using in Google Books. You think common law copyright is an older doctrine. You'd think that it would show up a lot in older stuff. You know what? It doesn't. I'm running short on time, and so does this make sense? And I know Christina Mulligan can talk a little bit later about the possibility of removing reproduction right from copyright law, and I think this is a really interesting case where actually there was no reproduction right. It didn't really matter. There was a strong right of distribution, and that was what it covered, and that was enough. So, tidbits. There is derivative works. Fair use is largely unknown. Venue and choice of law should loom very large in these cases, but are not really explored that much. And I think it's not clear to me entirely why, beyond the fact that they're kind of naughty doctrines. But in the Flow and Eddy cases, for instance, the parties have all assumed that the law of the venue state is controlling for purposes of the law. And there's no briefing on choice of law or anything like that. There really should be. I think it's an interesting question, especially because you have such broad things where there may be nothing in Florida, but unlimited protection in New York State. Obviously, choice of law should be extremely important. There has been a lot of controversy over DMCA and CDA for purposes of common law copyright. I don't want to get into that because we're running low on time. That's a major issue. There were some cases on that. So, yeah, the idea of common law copyright vets the right of an author to have full protection in a work until publication, and that's lost after publication. And this right, the idea that there's no reproduction right but a robust performance right, makes a lot of sense. The idea is it's all about the right to control distribution and how it's given to the public. It's not a right to make copies. That's copyright. What we're calling common law copyright, that's the right to control the manuscript in your work. So the problem with that is, okay, we're using this legal fiction that this is what protects sound recordings in many states that were made before 72 in most states, but it's not really what we think it is. And what does that mean? I mean, it makes a lot less sense if you look at it in context to think about, okay, we have these rights. If you say there's no production right, that doesn't really protect sound recordings the way you think it will. So possible solutions include federalization, uniform laws, negotiation of licenses. So there's a question that I ask, why is terrestrial radio not being sued? I think the answer largely is because the owners don't really want to. I suspect there will be lawsuits against terrestrial radio soon. There's no reason to draw a distinction between Sirius XM and terrestrial radio. Federalization would solve the problem in a heartbeat. Label owners do not want federalization. They're concerned for a couple of reasons. There is testimony where label owners say, and people from RA say, they don't care about extra damages, they don't want this. They don't want federalization. And you didn't mention a question. Until the 50s, it was very unclear whether there was any copyright protection for those records if they're still being made. Why? You get the question about incentives. So, my proposal is to sort of lead into this and embrace it. Embrace the performance right, especially as the music industry changes. It doesn't make sense to pretend that the performance right is becoming the main right really. It doesn't make sense to pretend it doesn't exist in pre-72s. I think it doesn't make sense to include radio either. And on the flip side, I think this really offers you an interesting laboratory to see how copyright would work without a reproduction right. As distribution and performance becomes the core of copyright. And this is something I saw at the patent office. Legendary bluesman B.B. King plays his guitar. His recorded performances are copyrighted, as is most of the music he plays. And he says, if only it was that simple. So, with that, I'll be happy to take some questions. Yes?
My understanding is that terrestrial radio is not being sued, have to pay royalties, so that's like the big...
Well, but that's what I'm saying. That according to what I'm saying, for pre-72 sound recordings, they should have to pay royalties.
Right, but how does that play into, so all the various, there's an obvious distinction between Sirius XM and terrestrial radio and Pandora. Sirius does a separate royalty proceeding that happens in DC for S-stars, and then we have the separate CRB proceedings. for interactive services and non-interactive services.
Right.
So under your conception of common law copyright,
But-
how would that?
Well, Sirius hasn't been paying anything to toners of pre-72 sound
Right.
recordings for use to sound exchange or whatever else. And that's why they particularly were sued. What I'm saying is conceptually there's no reason why terrestrial shouldn't be sued either.
Right, but the existence of the statutory license is precisely because Congress has recognized that to obtain that mass number of performance rights from that mass number of recording labels is very difficult given the uneven bargaining powers.
Right.
That's why there are these statutory licenses available so that you can set rates that recognize this lack of competition within the marketplace for recordings.
Oh.
So under common law copyright, how would that work? How would you prevent that disparity?
How would it work is an interesting question because you have, obviously it's not federal at all. It's all run by state law, but you now have the two biggest states saying there is a performance right for these and royalties have to be paid. So the one idea that I had was to basically a small model law for each state that would basically say royalties for sound recorders should be paid under the model basically by the federal government, and basically to opt into that program for pre-72s as well. Yeah.
So your history of the performance right for the musical works was persuasive. I didn't know about all that. But you just can't be right, can you? I mean, are you saying that in the history of time, from whenever radio was invented until 2015, there was this public performance right for sound recording on the radio that everybody knew about, but nobody thought to sue on?
Well,
for terrestrial radio. That just can't be right.
ASCAP certainly sued them, but ASCAP, of course, is a
But
composer.
that's for the work.
Yeah.
And that's the point. For musical work, there was a right. ASCAP sues.
Right.
All that 19th century stuff wasn't on the internet yet, so nobody
Well,
knows about it.
That's the thing. Well, it's actually on the internet, but no one's really known. Well, some of it is. The Chicago one actually is on Westlaw. But I think the answer is no. The composers sue like crazy, but the owners of sound recorders just didn't.
You can't just say just didn't. These are the most sophisticated people leaving billions of dollars on the table because they're stupid and just didn't want to collect the money.
Well, they weren't paying the stations to play their music most of the time. I mean,
They thought they were going to lose.
Thank you.
yeah.
So one solution, when you put the slide up there, and there were two questions that it raised when you said that we're using a fiction to say these works are unpublished. So why not just say they were published under federal copyright law, and hence they have no common law copyright, number one.
Yeah.
Why are you looking for an excuse to give these people a windfall that couldn't possibly play in the any sensible copyright incentive story that this will somehow encourage them retroactively to create more music? And then the second is, if they have complete rights in their works before it's published, why don't they have a private performance right too?
Interesting. So, second one first. I hadn't thought of that. That's really interesting. I will.
Especially if you look at the reasoning of the California court in the Flo and Eddie case, where it says you have complete property right, well, why not a private performance right?
The California decision is so weird because it's interpreting a statute. It's not common law. But I hadn't thought of private performance, but it makes complete sense. Why not? For the other one, I mean, that's a big question. I don't think I have time for it, but it is an interesting one. Thank you.
Thank you.